Copyright protects works of authorship. It's based in the Constitution, securing for limited times to authors the exclusive right to their writings. The scope of protection of a copyright is the right to reproduce the work in copies or distribute copies, to prepare derivative works, to perform the work publicly, and to display it publicly. Importantly, it does not extend to things that are not fixed in a tangible form of expression. So it's got to be something you can hold or see. It's got to be an article. It doesn't include titles and names, short phrases, and things. These are the types of things that trademarks are more appropriate for. If you have a slogan or a phrase or a name that you want to protect, you need to associate it with your goods and services, and it becomes an identifier of your products and services. So that's not appropriate for copyright. Copyright also does not cover ideas, procedures, methods, systems, processes. Some of those things are more the subject of patents. Of course, patents won't cover ideas per se, but implementations and practical applications of ideas are covered by patents. And copyrights also don't cover common property, things that are in the public domain, and things that have no original authorship. Collections of data in databases are generally not protected by copyright. The collection, you can have a collective work by pulling together a lot of things, and some databases sometimes can get some small modicum of copyright protection, but it's for things like, if you have a collection of links to engineering topics of interest. Even though each individual link is just maybe a URL to a PDF, your collection of them and perhaps the arrangement of them can be given some copyright protection. To get copyrights, there's no registration required. If you do register it, though, you get some advantages through statutory damages and other presumptions. It's very easy to do. It's a simple form that you file. To mark your products, you don't have to provide any notice. It used to be, prior to 1978, I believe, if you published your work of authorship without a notification, you basically dedicated it to the public domain. Which is why we are all inundated with the movie It's a Wonderful Life every holiday season.